The means test is used to evaluate whether Chapter 7 bankruptcy is an option. To determine whether the debtor was able to pay up back the creditors under the means test, the following steps are used. First, you calculate the debtor's current monthly income. Then you deduct some allowable expenses. Finally, we see what the remainder of these expenses is in order to gauge whether or not Chapter 7 is an option or not. First, we calculate the debtor's current monthly income. We average the debtor's income over the past 6 months, including the income and regular contributions. We exclude Social Security and victims' compensation. If the amount is below the median income for a family of that size, the debtor is eligible for Chapter 7 bankruptcy. Next, we deduct some allowable expenses. These allowable expenses are based on the IRS collection standards. Some for transportation and housing, some for food, clothing, personal care, and entertainment. But if the debtor spends more than the standard, a 5% increase may be allowable for food or clothing if found to be reasonably necessary. We also deduct the actual care expenses for elderly or disabled immediate family members or household members, private tuition up to $1,500 per year per child, additional energy costs, a 60th of the payments on secured debt that will come due within 5 years, a 60th of total payments for priority debts such as child support or alimony, and actual monthly expenses for administering Chapter 13 bankruptcy, which is the figure provided by the U.S. Trustee's Office. Next, we see what is left. If it is less than $100, there's no payment plan possible, and Chapter 7 bankruptcy will proceed. If it's between $100 and $166, and that amount is times 60 is not enough to pay for at least 25% of all the debts that will be eliminated over the course of 5 years, then there still is no payment plan required, and Chapter 7 will proceed. If the amount is more than $167, however, Chapter 7 is not an option unless there are special circumstances that the debtor can prove necessitate it. How does bankruptcy proceed? Well, after the meeting, you'll receive documentation constituting a bankruptcy discharge. The trustee will ask the debtor to turn over non-exempt property. Since the trustee will overlook property that is difficult to sell or not worth much, a lot of debtors don't have to end up surrendering any of their property. There is exempt property, and debtors can elect between two sets. First, equity in the debtor's home up to a certain value, equity in the debtor's motor vehicles up to a certain value, necessary clothing, household furnishing and goods, household appliances, jewelry, personal effects, or life insurance, all of these up to a certain value, retirement funds necessary for current support, tools of the debtor's trade or profession, but only up to a certain value, a portion of the debtor's unpaid but earned wages, and any public benefits that are accrued in a bank account can be saved. The major differences between the two sets of California exemptions include one set that allows for exemption of the home up to $50,000 if single and not disabled, $75,000 for families if no other member has a homestead, $150,000 if 65 years or older and physically or mentally disabled, or $150,000 if 55 and older, single, and earn under $15,000 or married and earn under $20,000, and creditors seek to force the sale of your home. The sale proceeds exempt for 6 months after received. Husbands and wives cannot double up on this exemption. The other set allows exemption of the home up to $18,450 with the unused portion of the homestead applicable to any property. In order to use either exemption scheme, you must have lived in California for a minimum of 2 years. There is also non-exempt properties. Expensive musical instruments, computers or peripherals, cameras, stamp or coin collections, family heirlooms, cash, bank accounts, stocks, stock and options, business assets, real estates that aren't occupied, boats and planes and off-road vehicles, or a second car or a second house are all non-exempt property and will be confiscated in order for the bankruptcy to proceed. All the documentation necessary. You need all your bills, every credit entity or collection agency that has contacted the debtor, and the names and addresses of people who the debtor could owe money, all of the names, any reasonable anticipated increase in the debtor's income or expenses over a 12-month period following the bankruptcy, the last 2 to 3 years of tax returns, pay stubs or other evidence of income received 60 days before filing, debtor's bank statements and other financial documents, leases or contracts to which the debtor is a party, and the debtor's property, real and personal. We'll go over this a little bit more detail in the next slide. The lesser values for the debtor's property means the debtor keeps more in the bankruptcy. Debtor's attorneys must do independent research and oversee the valuation process. In terms of homes, recent appraisals or comparable prices in the area or other recent approximations of value are enough. In terms of vehicles, the Blue Book value is sufficient. In terms of personal property, the debtor is given a lot of leeway in determining the market price for used items, but generally you should use garage sale pricing. In terms of the timing, if the debtor transferred greater than $600 to any one person in the last year, the trustee can recover it from the person and use it to pay the debt. But if the debtor has made any major purchase in the last 3 months, there will likely be a challenge for fraud. Because the cash is used to repay the debts, it is best to file right after the debtor has received the paycheck and use it to pay for basic necessities. Giving away property or selling it for less than it's worth the year before filing may be seen as fraudulent transfer or an attempt to leave creditors with less than the amount necessary to pay for their claims. So don't generally do that because you won't get away with it. In order to keep secured property, there's 2 options. Redemption. The debtor can buy secured property out from under the security interest for the lesser amount of the loan or the value of the property. It's the best option if the value of the collateral is depreciated and the debtor has cash on hand. Or reaffirmation. The debtor agrees to pay the loan or debt rather than having the bankruptcy discharge it. But they must agree to reaffirm the debt before the bankruptcy proceedings conclude, and the debtor must be able to show that they can repay the debt without undue hardship towards the creditor. After bankruptcy, all the debtor's wages earned and property obtained in bankruptcy is the debtor's to keep and the creditor has no claim to them. The debtor must report all insurance proceeds or proceeds from a divorce settlement within 180 days of filing. The debtor has a clean financial slate, although it will be difficult to obtain loans or credit at low rates for several years. Co-signers to any debtor's pre-bankruptcy obligations will still be on the hook for the entire amount of the obligation. This concludes American Advantage Law Group's seminar. We hope you enjoyed it.